We'd like to welcome everyone to today's webinar, Divorce During a Pandemic. Today, just a little bit of housekeeping before we get started. You can call in with your telephone, or you can use the microphone and speakers on your computer, whichever you prefer. We're going to be taking questions throughout the webinar. We know that there's a lot of questions surrounding this topic, so feel free to enter them in. We're going to answer as many as we can at the end. Whatever questions we don't get a chance to answer, we're going to send to the panelists today, and they'll respond to you afterward with an answer to your question. Today we have Rory Gannon from Smolin. Rory is a forensic and valuation services manager with the firm, and he's a licensed certified public accountant in New Jersey. We also have Alex Krisnamowicz. Alex is a member of the firm and a licensed certified public accountant in New Jersey with over 15 years experience. And also from Smolin today, we have Henry Rinder, who's going to be moderating the panel. Henry is a licensed certified public accountant in New Jersey and New York with more than 30 years of public accounting experience. And as our special guest today, we have Jennifer Weisberg-Milner from Stark & Stark. Jennifer is a shareholder and member of Stark & Stark Family Law and Divorce Practice. And with that, I will let Henry start his moderating.
Thank you very much, Amanda. If you could move us to the agenda slide, that would be great. And thank you all for attending our webinar. And I wanted to thank the panelists for showing up under the circumstances. We have a interesting topic today. We're going to talk about divorce proceedings and divorce topics during the COVID-19 situation. We're going to address what divorce process is like when you are sheltered at home. We'll talk about alternative options to going to court. And finally, we'll discuss impact on financial aspects of divorce like valuations, alimony, and child support connected to the whole COVID-19 situation. So I would like to ask Jennifer to perhaps, as we go to the first slide, to actually discuss the process under the current circumstances. Jennifer?
Thank you, Henry. So the New Jersey court system has actually done a very good job of getting itself online and being able to conduct remote court hearings. Unfortunately, however, the fact of the matter is that in New Jersey, the family court has so many mandated jobs. The courts have to deal with abused and neglected children. The court system has to deal with juvenile delinquents, and the court system has to deal with domestic violence cases. And because of this, and because of the delay that occurred in the very beginning of the pandemic, the fact of the matter is that divorce cases are unfortunately not ones that are getting to the court's rooms, the virtual courtrooms, as fast as we would have liked them. So what we're finding is that applications for post-judgment issues involving enforcement of alimony, child support, obligations under a settlement agreement, those cases are very backed up. For people who are in the middle of their divorces, the courts have just over the last week and a half resumed early settlement panels, and they're resuming what they can. The problem is that for the very, very vast majority of cases, trials are not happening. Trials are not happening because there are inherent problems with conducting trials, even when it's not a jury trial. In New Jersey, divorce trials are bench trials, where it's just the court or the judge that's hearing your matter. And because of that, judges don't have the ability to really look closely at people and make determinations as to credibility, have the opportunity to really look at faces, because not every litigant has the ability to have a laptop or other computer with a camera. So access to the courts is still a significant problem for many litigants. Also, courts can't look at what's going on behind the camera. Is there somebody who is helping somebody by holding up information that otherwise wouldn't be allowed on the stand? So that's one of the difficulties that we're seeing. The courts are doing motions via Zoom. They are happening regularly over the last, I would say, 3.5 to 4 weeks. The courts are trying to get a regular motion calendar. The courts in the family court had not had electronic filing. The last several weeks, we've seen electronic filing, so that access to the courthouse has changed, because prior to that, if we mailed something in, it was sitting in the courthouse for 3 to 5 days before anybody was even opening the envelope to make sure that there weren't any contamination issues. And finally, we're seeing a huge difference in how we deal with our clients. We're doing things by telephone, we're doing things interacting with various video platforms, Microsoft Teams, Zoom, Citrix, WebEx. We're having in-person video conversations with our clients, and those are picking up. So we're getting into our new normal, and attorneys are finding themselves in a position that we're absolutely able to communicate effectively with our clients, and we're putting together in a collaborative effort applications that have to be made. And we're finding some creative ways to deal with the process of how we get a client from where they sit today to the end of their case. And if we can have the next slide. So because of the problems that we're seeing with access to the court, as good as it is, it's still giving us a lot of challenges. So there are a number of alternatives that a litigant has to get their case resolved. And those, an umbrella term is called alternative dispute resolution. And there are 3 main ways that we as attorneys can help our clients resolve their divorce cases in an effective and economical manner. The first is mediation, which many people have heard of, and that's when the 2 different parties to a divorce, either with or without their lawyers, go to a mediator. A mediator is a neutral who's been trained to help the parties reach an agreement. The mediator is not going to tell somebody if it's a good resolution or a bad resolution, or if somebody's leaving something on the table. A mediator's job is to get you to the yes. Another very effective method that we're seeing more and more is arbitration. And that is when you hire a decision maker who is either an attorney who has significant experience in family law and has been certified and taken the training to arbitrate cases. We have a very, very strong group of family court judges who have retired, who are arbitrating cases. And so you have the benefit of somebody who has been on the bench, understands very uniquely how the court makes decisions, because that person was in that role of making decisions. And the attorneys or the litigants present their case the way they would to any other judge. And arbitration can either be binding, which is most often, the parties agree that they will accept the arbitrator's decision, or in certain cases, they can work in the right of appeal into an arbitration. So if either party is unhappy with the decision, they would go then to a panel of arbitrators to review the case. And then finally, another way of resolving cases is something called collaborative divorce. People aren't as familiar with it. And a collaborative divorce is a team approach. You have specially trained lawyers, and we enter into what's called a participation agreement. And we agree that we're going to settle the case, and we agree that we're going to stay out of the courtroom. And the incentive to stay out of the courtroom is that the litigants sign an agreement that says if the case does not settle, they have to find a different lawyer. They cannot use their collaborative lawyer for their litigation. And that gives everybody incentive to try to resolve the case. And we often have financial advisors who look at the overall finances of the family and come up with creative ways to settle the case. And we also have typically mental health professionals who assist with any custody situations. And as I said, it's a team approach, although people have, each person has their own lawyer. the idea is to be creative and find a way to resolve the situation. And given the unique challenges that the pandemic is creating, that type of approach, no matter how you go about it, is going to be important, because this is going to be a situation that it's going to take a while for the law to catch up with the reality. And we need people who want to get our clients to the finish line in a fair and equitable way.
Thank you, Jennifer. As we move to the next slide, we're going to address some of the economic effects of the pandemic. And Rory Gannon, can you, Rory, address in the business valuations the current dilemma that we are facing in terms of uncertainty and valuation date, and the effect of those on cap rates and projections of future cash flows? Rory? Something happened to Rory? Are we still connected?
Sorry, I had myself on mute. Okay. So typically in the state of New Jersey, the date of complaint is the end-all and be-all valuation date utilized for equitable distribution of marital property, including business interests. So a issue with this would arise if, for instance or example, the company that is subject to divorce actually declines substantially or goes to zero during the divorce. It brings about the question as to whether you can bring in the current valuation as of the current date instead of using the date of complaint value if that asset has declined in value substantially. And in New Jersey, there is a case known as the Goldman case in which addresses this specific situation where during a divorce, after the day of complaint, the business had a substantial decline in value for which the judge in the case was receptive to hearing that portion of the argument as to, okay, well, let's not tie the value of ED to the day of complaint when there isn't any value left in the company. And so there's going to be a need that arises in certain divorce cases for which either the business substantially declines in value or completely goes out of business during this whole time frame. So, for example, if a couple in a divorce, if one of them were to, say, own a gym company or a company that owns a gym property, that company is clearly not receiving revenues from their typical client base during this period. However, they're on the hook for paying off the lease expenses month by month, and it is a very scary situation for the business in which it's uncertain at this time whether it would be able to continue into the future, because typically we're valuing these entities in a divorce as a going concern. Now, if a need arises to go off of that, if the company is going to go out of business, then a going concern isn't really practical for the divorce, and it's something that should be brought to the attention of the judge that, hey, this is the value as of the day of complaint. However, these are the items that we have seen due to the coronavirus that have now caused the date of complaint valuation to not really be what is representative of the situation in this marriage. So another item that will come about is the effect on capitalization rates, which are used to capitalize the cash flows of a business and arrive at a valuation. So we typically, as valuation experts, utilize data of that historical financial data in order to project the future and to capitalize the earnings. And, you know, typically we may look at a period that's 20 years or more. However, now in the last 20 years, if we look at it, we've had not only the current coronavirus issues, but we've also had issues associated with the 2008-2009 mortgage crisis. So now we have two blips in the data for the last 20 years, which will cause for there to be outliers in the data. So that would bring us into performing either regression style analysis of the data to figure out a proper capitalization rate going forward, or to utilize data that is done in similar fashion by companies such as Duff and Phelps, who come up with every year a normalized cap rate. So it takes out and normalizes the situations that occurred during that time period, such as the coronavirus pandemic, and then in the past, certain events such as the mortgage crisis or other recessions that have occurred over time. And then there's an impact to the projections of cash flows. So not every entity do we value using a capitalization of earnings, but in some cases, there's a need to do a discount of projected cash flows. And being that business owners are not able to effectively forecast out when their company is going to go back to normal and when their revenues are going to go back to normal, it provides challenges in the utilization of the discounted cash flow method because of the relative uncertainty in the business going forward.
Thank you, Rory. Alex, on the next slide, we are addressing other economic impacts that pertain to divorce due to liquidity issues for the payers of alimony and child support. Could you shed some light on what we are seeing in practice in this space?
Yes, Henry, absolutely. Thank you. So with all the volatility and uncertainty in the market that people are experiencing, in particular, layoffs, furloughs, changes in their earning power, drastic decreases in retirement and investment accounts, and as Henry mentioned, liquidity challenges. In the past, we've had the luxury of using history as a proxy for the future in estimating people's ability to pay on agreements, old agreements, new agreements. But now that may all have to change. It's not easy to convince a court, a trier of fact, that a past agreement should be amended. Under the circumstances, it's a little early to prove that a decrease in compensation may be permanent. If you do your research, as simple as a Google search, or if you're watching the news, economists vary in their opinions. I'm reading anywhere from a year to 3 years for a full recovery. If you believe the White House briefings, all should be okay by Labor Day. That may be a timetable that's politically motivated, though. So what it comes down to is, as financial experts, as attorneys, we're having to do analyses of both past and future income. And hopefully the courts will take some consideration of both going forward. So as a litigant, you're going to want your team of professionals to prepare your financial position that's believable to a mediator, arbitrator, or a judge. In our practice, Henry, Rory, and I are very much seeing a little bit of everything. We've seen everything from an extreme of individuals that have such significant wealth that maybe they've been affected by the pandemic, but their assets are so large that there's zero chance that there's going to be an adjustment to a past agreement, or that they're not going to have an ability to pay going forward on a new agreement. And then we've seen clients that have just been absolutely devastated, that, in negotiations, a mediator, or if we end up in court, a judge is going to have to absolutely consider that a person may deserve an amendment. on a past agreement, or last year's income may no longer be relevant in current divorce negotiations. I have a client now that, who made 7 digits in income last year and isn't going to even do half of that this year. Still a significant income, even in New Jersey, but certainly a big enough decrease that the ability to pay changes. So is that change permanent? That's what's going to be difficult to prove. That's what's going to be difficult to know going forward. Henry, Rory?
Thank you, Alex. So
sure.
On this point, I wanted to just add a couple comments. And frankly, at some point, I would like to get Jennifer to weigh in on this in terms of modification, because if you have a change of circumstances, even before coronavirus, obviously there were means to establish a change of circumstance and move to modify either child support or alimony. And I'm not certain that this is in terms of process much different, although the question is it really permanent? Rory, you wanted to mention something before we jump?
Yeah, I just wanted to emphasize again the liquidity challenges, because if a couple were to have large interest tied up in, say, commercial real estate properties, as an example, during this whole coronavirus pandemic, they might not be able to liquidate those properties very easily. For instance, if someone has a commercial real estate property that has 5 tenants prior to the coronavirus, and then 2 of them have just gone out of business because of the coronavirus, then this real estate property is now in a search for new tenants to take up those spaces, but they're also competing with other commercial real estate holding entities which hold properties that also have been affected by this and have had their own tenants leave. So there is a change in the supply of the commercial real estate properties, and by doing that, it causes that property to have a lower ability to be able to be liquidated, because people are less likely to invest in a property that is at, say, 60% occupancy if it used to be at 80%, and they're not going to pay the same amount of money. And then on top of that, if this couple depended on the cash flows from this real estate property, it may have potentially gone from them receiving positive cash flows to them having to pump more money of their own into the property, because they now don't have the ability to collect from certain tenants, or they may need to go and hire attorneys to then start collecting against certain of these tenants, which could cause for some further liquidity issues.
That's a good point, Rory. Going back to Jennifer. Jennifer, so we have a current change of circumstance, and in some cases it may look permanent. It may, if the business closes, obviously, and somebody has a high-powered position, at least that job has been eliminated, and perhaps replacement of a job that is a high-powered job under the current circumstances is not going to be the easiest. So what is your take on how the courts will look at sort of like this short-term change of circumstance that's taking place under this pandemic, and how they're going to view it from the perspective of modifying alimony and modifying child support? Jennifer?
Well, I think that this is going to be an area of the law that's going to evolve very quickly, and it's going to be very fact sensitive. The reality is that we are in an environment of special circumstances, and the family court is one of equity. And one of the questions that's very often asked when a family court is determining whether or not to grant a modification of obligations under either an existing court order or an agreed upon marital settlement agreement is, what would this family have done if they had remained together? So in other words, if you have one party who has the vast majority of the obligation for the finances, if you have a situation where one of the parents of a child earns a significant salary each year and the other parent is not someone who has that earning capacity, if they were still together and the breadwinner of the family had a furlough that was going to last 6 months, well, that family together would likely have to tighten their belts and make significant changes in order to ride out the storm. The courts are likely going to make sure that the parties together experience some amount of change and equitably distribute the problem, so to speak. If the person who is experiencing a furlough, a layoff, or a termination of their job and wants to have the court review those support obligations, they've got to be prepared that the court is going to want to do a pretty deep dive and see what other assets are available to that person in order to pay support obligations. Typically, the law has been that you've got to demonstrate more than a temporary change of circumstances. But I don't think you're going to find any attorney worth their salt, certainly in New Jersey, and I would dare say throughout the country, who would tell you that in this extraordinary time, a temporary change of circumstances is not going to warrant a reduction in certain cases, because there is no question this was nobody's fault. And the courts are ones, as I said, of equity, and there is little question in my mind that we're going to have to deal with the uncertainties that we do not know how long it's going to take somebody to get back on their feet, and if they even get back to the level that they were earning previously. Henry?
I think that that's a good question, and that's kind of what we've been seeing across the board. People are wondering at which point they can. One of the questions that we actually had come in that maybe you might have some input on, is that I know initially the general consensus was that we have to see what's going to happen, and it takes kind of a sustained period of time to warrant that change. But at this point, would it be something that would be open, the layoffs, because we have the stay-at-home order that it's indefinite in New Jersey, there's no clear end in sight. Is that something that we would be able to kind of, people could petition for now? Do you think that the judges might be open to hearing that?
I certainly do in certain circumstances. If you have somebody who has been has had a reduction in their income because of the fact that maybe they're only working 50 or 60% of the time, that person's going to have to talk to the attorney and just see whether it makes sense to wait it out a little bit longer. It certainly appears that Governor Murphy is trying to get us to a point, as long as the data of the virus comes down, that he wants to start opening us up slowly. On the other hand, if you have a business that has been completely shut down, and if let's say you own a gym, it is highly unlikely, from what we read in the media, that gyms are going to be open anytime soon. That's a situation where certainly you want to look at getting a temporary reduction in your obligation. And if nothing else, even if you don't think, or your attorney doesn't think, that you may be able to get a termination or a reduction, what the court can do, and what they are doing, is they are not enforcing people who are in arrears, as long as they can demonstrate that there's not any fraud or somebody who's just trying to utilize this as a reason not to pay their obligations. So there are several remedies that can get us past this immediate issue, and then we look to see what the likelihood of where things are going to be. If you're a boutique owner, if you're going to be allowed to be open, then maybe the last 6 weeks or 6 to 8 weeks are not going to have as much of an effect. On the other hand, if you're a restaurant owner and you're only going to have 25% capacity, and if you're employed, even if you're employed by that restaurant, you're not going to be earning anywhere near what you're going to be. So this is certainly the time to start getting your case in order and talking to see what's the best option for your particular situation.
Amanda, we probably have time for one other question. Do you have anything else that's coming from the audience?
That was actually the question that came up, was the business valuation. I don't know if Rory and Alex, if you guys have any input about what the business valuation side would look like in the prediction models for you guys, based on the past earnings, the current closings, and what the future would look like in terms of either changing it or if you're proceeding with a divorce now.
Alex, you want to take it?
Yeah, sure. We're always looking at the past when we're preparing a business valuation. And again, the point that we use the past as a proxy for the future. However, I think now, trying to look ahead, while always relevant to the business valuation process, I think is even more important now, because with companies, small, closely held businesses feeling a downturn, and again, having to assess how long that might last, what the risk portfolio looks like for the entity going forward, the ability to continue as a going concern, how long a downturn may last. All these things are going to be considered. They're all going to affect the way we look at it and form an opinion of value on an entity. It's the climate has definitely changed, and all these things have to be considered on a case-by-case basis. There's no doubt about it.
And surely, Alex, we're gonna be looking at, predictions of when the full reopening is gonna occur, what kind of impact that will have on the revenue stream, to the future cash flows, and that's a lot of guessing, unfortunately, and a lot of guessing also brings up the risk that that our projections may not be accurate. So that uncertainty actually by itself would imply that the value of the business is lower, just from the uncertainty alone. Rory, don't you agree?
A lot of it also goes into when is the day of complaint. So because we are kind of stuck with just bringing into what is known and knowable as of the valuation date. So at what point did it become known that coronavirus would have this level of impact in the United States? Was it January 1st, 2020? Was it March 2020? Was it sometime in 19 when it was affecting China a little bit more? A lot of that has to go into it. So it all depends on when the actual date of complaint is, too.
But surely the attorneys for the titled spouse will ask for us to do a valuation, the current value valuation, because of Goldman. However, we are running out of time, and so let's just reiterate to everyone that to the extent we didn't answer your questions, Amanda's going to circulate them to the panelists, and we'll do our best to get back to you by email. As we come to a conclusion of this webinar, I just wanted to thank the panelists, Jennifer, Alex, and Rory. Fabulous job. And I wanted to thank everyone who attended today's webinar. Have a great day and stay safe.
Thank you, Henry.
Thanks, everyone.
Bye.